This webinar, as it says, is about termination, and I'm really delighted that you've all joined. Our guest speaker is Karen Goff. I've known Karen, obviously I can't have known her that long because she's still very young, but Karen practices as counsel and attorney, adjudicator, arbitrator, and deals with ADR. She's specialised, she's put down the number of years, but surely it can't be that long, Karen. She represents a wide range of clients, governments, contractors, subcontractors, and she's dual qualified in the Caribbean. I know that she's an incredible speaker, and particularly on FIDIC, because I've had the pleasure of speaking with Karen on a number of platforms, most recently in the city that I still can't pronounce, but it's in Georgia. Come on, Karen.
It's Tbilisi.
I have a complete mental block. I can say many intelligent things, but I just can't say that. I've already mentioned that there is the chat function, and we've got a lot of different people here, over 30 countries. It really helps me in terms of what we are trying to present and provide to all of you. If you could put in the chat the country that you're from. Can you also put in the chat the main form of contract that perhaps is used in your country? So, for example, in the UK, England and Wales, we probably use JCT the most, but can you put the contract that you actually use the most as well? So it might be that it's JCT you think, but you use mostly a form of NEC contract. And also, please put any questions in the chat as you go through. I will try and go through the chat at the end, pull out any questions. If you've got anything that's more specific, please email either Karen or myself, and we will try and answer them. I totally understand that some things are a bit more delicate and you just want a heads up, and I'm all for providing you as much information as possible. I'm just checking, I'm following, doing what I'm meant to be doing. Okay, so I'll come back to some other things at the end. As I say, this month we're talking about termination, and so I am providing you, after this webinar, you will get an email that basically says, thank you very much for attending. I do ask for a little bit more information, and in return, that email has a link that will take you back to our website, from which you'll get the detailed notes that I'm just going to read now about in relation to termination for NEC and JCT. You will also get there is the clauses in relation to JCT and NEC about how you actually follow the process of termination, and you get a full comparison. So I'm not really how to show this. So full comparison, which is a table. I know you know what a table looks like, but it just makes me feel better showing it. So you get a table that is a comparison of all the clauses between FIDIC, JCT and NEC. So we've looked at all the different termination provisions. There's also some sample termination letters as well. So there's a huge amount of information that you will be able to download. And for that reason, I am not going to spend, you'll be very glad to hear, a huge amount of time talking, because obviously the person we want to hear from is Karen. So I'm just going to talk reasonably briefly about the issues between the contracts and termination, and then touch on repudiation. And in order to follow one of my basic themes, Karen will know this, because I hate putting lots of words on my slides. This month, I've decided that one of the underlying things to make this learning fun is that there is a film theme to my slides, okay? Just to make sure that you're paying attention. So, you don't have to put it in the chat, because I will ask you, or tell you that as we're going through, you need to be thinking about the slides. So obviously I've done the intro, beautiful pictures of us two, charming, I think. I should have said Karen's from 39 Essex, who are fantastic chambers. Karen, tell you more. Blurb about me, you know, yada yada. So we start with the battle of the different forms of contract. So you can be thinking about which film this is from. So I'm going to look at a number of slides, and we're going to have a detailed presentation across the table that we have produced relates to FIDIC Silver Book, but I think Karen has looked at the Red Book. I just took an older version because in my experience, most people on international contracts, you haven't quite updated. We're looking at JCT Design and Build, because I think that's probably 2016, almost the most prevalent, although I have just been sent a job where it's on the 2011. Absolutely really good contract still to be using. And then NEC 4, which is from 2017. So if you didn't know, this is from Lord of the Rings. So introduction. We're going to look at termination and the reasons to terminate under the different contracts and common law. We're going to briefly look at the process whereby you notify the other party and the process that must be followed after termination. And there's also, I'm not going to go into it, there's also a section you'll download about relevant case law. And of course, this film is Anchorman because it's all about the introduction. Summary, this is, sorry, very tenuous. So this might test more of you, this film. So each contract gives some specific reasons why and grounds you can terminate. Those reasons include, amongst other things, insolvency, default by the other parties, and corruption. But you have to bear in mind that JCT, for example, refers to English insolvency legislation, whereas NEC 4 and FIDIC merely use the terms liquidation and bankruptcy, but without reference to English insolvency. And that's because they're intended to be used in a more international fashion. As I mentioned, the default provisions, so in FIDIC, the contractor can terminate where there's non-compliance with clause 8. So sorry, if they're not complying. And in NEC 4, again, if the contractor's substantially failing to comply. So some of the language between NEC and FIDIC is similar. And I think that's because NEC seeks to be no longer an English contract. It wants to be a more international contract. JCT, on the other hand, uses what is well known to English parties of failing to proceed regularly and diligently. And that language is quite unusual. So, and if you didn't know, this is from the film The Beach. And of course, I was giving you a summary of what we're going to talk about. Okay, NEC contracts provide further detail, but once you've made out the grounds to terminate, you must provide notice to the other party. JCT has separate subclauses that provide details about the notice and how it should be delivered, whilst the other contracts don't have specific subclauses. They all do deal specifically with notice, but it's set out in different places. But you must refer to those clauses. And my point here, and those of the older amongst us will know that this film is Basic Instinct, wonderful Glenn Close. You need to follow your basic instinct and the basics in getting your notice of termination correct. It must make it clear that your notice is sent to terminate the contract. It must be in writing. It is probably required to be a separate form of communication, so that's NEC specific. It is usually served in hard copy unless you have provided within your contract that it can be sent by email. So usually it's going to be by hand or post. It will need to be served at the address in the contract. So what is that address? Is it the registered office? Is it the site office? It may well need to be addressed to a person, individual named in the contract. And it will have to be covered by that to that individual. And the point is here, I accept that if, for sake of argument, the contract says you send it addressed to Karen Goff and you send it to me, you've complied. But what happens if someone does argue and say, well, actually, you know, Karen's left the organisation, we deleted all her emails, we didn't get the notice. You don't want to be opening you or your client up to disputes, jurisdictional arguments about something that should be straightforward. So my advice is follow your basic instinct. It's better to put it in and to be clear than to miss it. So JCT, as I've said, doesn't give you the option to serve by email, which is one of the reasons why you should always get a solicitor to help you review a contract and or amend it. NEC does give you the option of providing notice via a communication system. So in a lot of NEC contracts, they will use the equivalent of Teams or Dropbox for exchange of information. So that may well be how you serve it. And FIDIC does give the option of providing the notice electronically, but again, that must be set out in the particular conditions. Note that termination under NEC must also be sent to the project manager, regardless of who else you're sending it to. So, subject to compliance with those basic points, you can terminate. So that notice will have effect, and that is to say it will terminate the contractual relationship with the parties after the following. So in FIDIC, it's 14 days after notice has been given, or immediately if the reason for terminating is related to corruption or insolvency, or 28 days after a notice has been received under clause 15. Under NEC 4, the project manager issues the termination certificate. Under JCT, if the reason for default is either party, then an initial notice must be given, and then that default must continue for 14 days. But then you have to serve a second notice, and this is quite often misunderstood in JCT. So after that 14-day period, you then have a period of 21 days in which to give your notice. And it's an unusual thing, contrast between JCT and others. But you must serve your notice within that further 21-day period to terminate the contract. If it's on 22 days, it's an ineffective notice and you have to start the process again. And there are arguments for and against this. You know, will that default really be continuing for 21 days? What happens if there are, you know, they've sent one man and a dog and a pony onto site to do some work? Are they now regularly and diligently? Have they corrected that default? So these are things you need to think about. And again, I go back to the previous slide, you need to follow your basic instinct, but be very careful about how you deal with it. But bear in mind that termination is not the contractually final step. Parties need to be reminded and must realise that termination brings to an end your contractual relationship going forward from that particular date, but it doesn't alter the contractual relationship up to that date. The contract exists and disputes and liabilities remain to be decided under the contract. And there may be things that are left hanging, and the termination provisions need to provide for that. So how are you going to deal with, for example, insolvency, very prevalent? Are you going to amend the contract so that's on insolvency, it's an automatic? Do you want to have, as in JCT, the option of continuing with the works? Under other termination provisions you bring in, what you want to do, and especially over recent months, and I haven't been quite done to death, but there's a lot of discussion about force majeure, COVID, sorry, has to be mentioned, and we have the same, we've still got, don't forget, Brexit with a no deal, excellent, well done Boris, not. There are still those sort of things that you're going to have to think about in your contracts. And it's not just England and Wales who's going to do silly things about leaving the EU. Other countries may split apart and move, and you need to think about what may happen and look forward. But each contract must deal with what happens after termination. So, as Ben said to Peter Parker, with great power comes great responsibility. And that's because your contract must provide an account that they provide an account for what will be provided to determine who is or is not owed money after termination. The employer might have the option for completing the works. The contractor may be obliged to remove its equipment and plant from the site, or you may change that provision so that the equipment and site can be retained and used by the employer, perhaps subject to a further payment. It needs to be noted that NEC provides for a different combination of procedures following termination, and all of these may include the option for the employer, client, project owner to finish the works at its own accord. JCT sets out in clauses 8.7 and 8, so when the employer terminates, and clause 8.12, when the contractor terminates, what may or may not occur. So you need to, in my view, look at these sort of things. I know, and I always talk about it, when we start a contract, we're all sitting round a fire, singing Kumbaya and holding hands. Most of us wouldn't be in a job if everybody did that. Thankfully, it doesn't happen. But you need to think forward and decide, do you want to change the termination provisions? But bear in mind that if you change the termination provisions, normally what is good for the goose is good for the gander. So if you're changing a timescale or applying more pressure on a contractor, there are going to be arguments coming back from the contractor that similar obligations will apply to you. So you need to look at these clauses carefully, and in particular look out for words such as may, which implies an option but not an obligation. Or does the clause say you shall do something? It's an obligation. So you need to determine when you can and cannot do something. And for example, I've had a dispute recently about the use of a clause that said shall and forthwith, and whether or not that was a condition precedent. So do you want to impose condition precedents before, for example, a contractor can terminate? And FIDIC sets out the one thing that must occur if the employer terminates a contract, and that's the creation of an account setting out the sums owed to the contractor or the employer. And if the contractor terminates the contract, then there's a number of things that will occur, including the contractor stopping any further work. But those are all of the things I've talked about are under the standard forms of the contract I've referenced. And you are normally looking to amend these in some way. My point is trying to amend your clauses practically and commercially for the project that you are dealing with. And I think my role as a solicitor is I normally amend things, but I want to discuss it with my client. I want to speak to the project manager. I want to speak to the engineers who are going to be working on that job. What do you see as being the problem? Is it time? Is it the site confines? Is it supply of materials? Is it the importation of goods? Is it impositions of the type of quality of material that is coming in? Is it going to be import duties? And where we are working, are there going to be issues with labour? You know, visas? Are there going to be now issues with COVID if you have to bring things in? Or people, will they have to self-isolate? How's that going to play out on your job if someone has to self-isolate? And what's your use of technology? You know, we're not very good sometimes with technology, but again, you need to think of these and how these interplay on your contracts. And I would say the larger and more international your contract is, you're going to have more international parties, and you're going to have more people and communication issues. However, moving on. Okay, so you're looking at the film and you're thinking, don't see the connection. Well, so Eurovision, and this is all about what happens if you get it wrong. So Eurovision is a classic film about beautiful, brilliant film, recommend it, very funny, but it has a number of things wrong. In the opening scene, for example, it shows everybody drinking hard liquor, and it's set in 1974, but Iceland had a prohibition on hard liquor until 1989. Also, from this picture, the film starts in 1974, which means they should both be in their 50s. There's somebody in this picture who really doesn't look to be in her 50s. And if she is, then that's a miracle of modern science. But repudiation, That is what happens if you get it wrong. And that's when a party shows he does not intend to accept or abide by his obligations under the contract. And a repudiatory breach can occur in two ways. So when it's the guilty party has breached a term of the contract which is sufficiently serious to justify termination, or where a party has acted in a manner as to show that they no longer intend to be bound by the terms of the contract. And if a repudiatory breach occurs, then the innocent party is entitled to terminate the contract, ending that contractual relationship between the parties and entitling the innocent party to claim damages for breach of contract. However, the innocent party is also under a duty to mitigate the losses it suffers, but as in the film Matrix, there is a choice. Do you accept that repudiation or not? What steps are you going to take? And are you sure of your grounds for repudiation? Because it may be that you are trying to set up a repudiation. Heaven forbid that we solicitors would ever do that. But you may be trying to set up a repudiation. But you should, in my view, you should also hedge your bets and be careful that you might still need to be serving contractual notices at the same time. An example of repudiatory breach would be if one party attempted to terminate the contract, but they couldn't make out the grounds validly to do so. And the point being that the offending party's intention to terminate without a valid reason is a strong indicator that they do not intend to be bound. So they take steps under the contract, they don't comply with them, and then they say, we're terminating. Other examples include the employer consistently not providing access to or possession of the site, the contractor not removing essential items that they've been instructed to. So what you need to consider is repudiation can be hard to establish. An authority has found that repudiation should only be alleged in cases where it is clear that a refusal has taken place to perform contractual obligations that go to the root of the contract. So it's a serious nature. Be careful, be wary of alleging repudiation. And my advice is always look to the contract first. That is where you started, and repudiation should realistically be a last resort. And if you're an innocent party, then you've got the two options, as it shows here. You can either acknowledge the breach, but not terminate the contract, or you can terminate. Last bit, act promptly. The longer you dwell on that issue, the harder it will be to show that the action actually amounts to repudiation because you haven't acted on it straight away. So, as I said at the beginning, you will get an email tomorrow and you'll be able to download the guide for termination. You'll see that we're setting out the contract processes to be followed. We set out a comparison from the contracts. There's a discussion, a much fuller discussion on repudiation. And there is also a load of very exciting case law that I hope you all enjoy reading. There's a number of, and there are some template letters. They're for guidance. Obviously, we have our usual caveats splashed across them. So we move on to the delectable and very intelligent Karen. If you are ever in need of advice on FIDIC, Karen is my go-to counsel. I'm not sure you're allowed to say go-to woman anymore. So my go-to counsel. One of the benefits of instructing Karen is that there are a lot of excellent junior counsel at 39 as well. And it's important because Karen has their support, so you can effectively use Karen as your leader and you've got more junior support. Karen has worked with me, advised me on more cases, lots of cases, trials, adjudications, and utterly fantastic. I can't recommend Karen highly enough. And she speaks a lot for IBA and other organisations, DRBF, across the world on FIDIC. So I'll hand over to Karen. Karen, do you want to just tell me, and I'll click on the next slide, or do you want to take over for yourself?
Good question. I'll I'll try to tell you, I think.
Okay, you tell me. Well, I'll put the first slide up, and you can wave or just say Bill, and I will be at your bidding and go on to the next slide.
Great. All right. Thank you very much for that, Bill, and thanks for the introduction. And yes, big thumbs up to the junior team at 39 Essex. We've got some wonderful juniors. So, you know, we cover the whole range. But FIDIC, okay, I'm going to talk to you about FIDIC today. Bill's already mentioned some of the clauses and some of the provisions in FIDIC. I am only talking about FIDIC, so I hope that I can sort of bring together what he said to give you a real snapshot of what is happening with FIDIC. To carry on the film analogy, Bill, there's this film, I think, I remember the name saying, we need to talk about Kevin. Well, what we need to talk about regarding FIDIC now, I think I've come to the conclusion, is the 2017 form. The majority of the world, I think, is still using the 1999 forms, the first edition of the Rainbow Suite. But actually, we need to get to grips with the 2017 form. It's been picked up by the World Bank. In fact, it was picked up by the World Bank, I think, in 2018 or early 2019. So it ought to be used more and more. We have all the ramifications of COVID to deal with. There are likely to be terminations. So we ought to be fully au fait with the 2017 form. And the provisions in the 2017 form do not mirror, as far as termination is concerned, do not mirror exactly the 1999 forms. As you've already said, I'm going to talk about principally the red and yellow book. The silver book, the terms are broadly similar, but of course we don't have an engineer in the silver book, we have an employer's representative. But for most purposes, where it says engineer in the red and yellow book, you can read employer's representative in the silver book. It's not that difficult. So first of all, the second edition was about 5 years in the drafting, and the big question for me always has been, has it improved a great deal by reason of all that time and cogitation? And I was part of that cogitating team, so I know that a huge amount of work went into it. In some respects, I'd say yes, and in other respects, I would say no. And I think a little bit also depends on the sophistication of the construction industry in your particular jurisdiction. Because the 2017 forms, and this is particularly important in relation to termination, is very much more prescriptive. It tells you what's to go in a notice. And since there are lots of notices and lots of time bars if you don't serve the notices or put the right things in the notices, it's important that you pay great attention to the form, which I think, Bill, is what you were just saying generally about all of the forms of contract. If you're going to make a contractual termination, you need to be on top of the formalities. And if you're even thinking about it, I would say to you, get advice before you jump ship, not after, because picking up the pieces of a broken termination is great for lawyers, but it's an absolute disaster for commercial clients. So be careful always when you're even thinking about termination. And indeed, my advice with termination is don't do it. If you can avoid it, if there is any other possible option, do not terminate the contract. So it's a good time to talk about termination. As I say, inevitably, there are going to be a whole raft of terminations, probably many contracts already suspended. It may or may not be possible to restart some of these suspended contracts, but there are likely to be terminations for lots of options, including, of course, insolvency in the near future. So rather than talk about COVID and the effects of government changes in the legislation and the pandemic and shortages of materials, these are all things that are going to lead to the prospect that contracts can't be continued or will have to be terminated and started again at some later time. So I would say always with anything, take a principles-based approach. Always begin at the beginning and be super pragmatic. So think carefully before you start insisting on your strict contractual rights. And that is more important than ever, than any other thing, I think, when you're thinking about terminating. You might have a right to terminate, but the question is it the right thing to do? You need to work out what you want to achieve as a result of a termination. Whether you're a contractor or an employer, you have to be really, really careful what you wish for, because you might just get it, and then when you get it, it might not be at all what you want. So if you think you have a right to suspend works or terminate, think long and hard first. A suspension might, of course, be inevitable. Practically, there might not be another option, but termination is always optional. At least, I think, in the near term, save, I suppose, except for things like insolvency or indeed corruption. I think there are some things that you just can't row back from. So don't terminate if you don't have to. If you are going to terminate, what have you got to do? You first of all got to establish the contractual obligation. You've got to prove that there's been a breach, and a breach sufficient to found a termination. And that sounds quite trite. You know, you say, well, we all know that. Well, if we all know it, the question is, why don't we all do it? Because 9 times out of 10, if a termination is going to fail, it will fail because those basic steps have not been taken, because you haven't really considered whether or not the contractor has actually failed to proceed with due diligence, whether there are definitions of these things in the contract which actually describe what constitutes due diligence, or legal principles that will assist you. And if you just think, well, actually he's running late, we'll just call it a day, you may not have a right to terminate at all. And I think, as Bill has already said, if you get it wrong, you are then in the position, perhaps, of committing a repudiatory breach of contract, and you may just have it shot straight back at you that actually you've caused a termination. You're the one who said you're no longer going to be bound by the contract, and at common law, you could then be in repudiatory breach. So if you're in that park, if you're in that area, maybe the right thing to do is suspend first, which is more than likely, certainly under FIDIC, you would have a right to suspend, whether you were the employer or a contractor. The grounds of suspension are set out. And then try, if you think that termination is inevitable, try to make some kind of deal so that there is an agreement to bring the contract to an end, rather than enforce a strict contractual right and enforce a termination, which then becomes a very confrontational situation. With FIDIC, of course, you have a very broad structure, and on the slide, you know, suspension, have a negotiation, make use of the dispute avoidance procedures under clause 21. Clause 21, you can try and avoid it, and if you can't avoid it, you can get some adjudication. A DAAB decision is a much cheaper route than a failed adjudication, because you didn't have the right rights. Get some clarity around your complaints before you go down the termination route, if you possibly can. Termination by agreement, as I say, is the preferred option. Under FIDIC, the employer, of course, has a right to terminate for convenience, and those rights changed slightly in 2017. In the 2017 form, there is the possibility that the employer can simply terminate for convenience, because actually they could get someone else to do the work cheaper, or they could do the work themselves. That was not possible under the 1999 form. Although even under the 1999 form, I never had to deal with it, and I have not yet had to deal with it, but it always struck me as something of a sort of vacant obligation not to do it yourself, not to give the work to a third party. Because if you terminate and you pay off your contractor, who's going to stop you doing it yourself or getting someone else to do it? But under the 1999 form, you can't terminate just because you got a better offer somewhere else. Under the 2017 form, you can, but it costs you, which is fair enough, it seems to me. So even under the 2017 form, of course, under the usual provisions of the contract, you can't just omit work and give it to someone else and keep the contract alive. I just make that point for clarification. Bill, I can't remember what's on the next slide, but could we go to it? Okay, right. Well, I think Bill did talk to you a bit about what the FIDIC termination provisions included, and certainly there's a two-step process in the FIDIC termination. I'm going to go through employer's termination and contractor's termination. But the employer, if it's got a problem with the contractor, should issue a notice to correct. And a notice to correct under 15.1 is giving a heads up to the contractor that all is not well and something needs to be corrected. And the contractor, as you can see from the provision, has to respond. And as Bill mentioned to you, if you're going to be in this situation and you're going to do anything at all, and certainly if you're in receipt of a notice to correct, you need to respond promptly. And quite often when you start these notices, notice to correct and the response to a notice to correct, you see at that point, you can get a good handle on whether or not you're actually going to head towards a termination provision, because the correspondence heats up immeasurably. Either somebody will jump to and put something right, or they will join issue and they will start a fight about it. And therefore, if you're going to do something about it, once you've issued your notice to correct and got a response, that's a very good moment in time to get on to some kind of process to really resolve the difficulty, if it's capable of resolution. So the thing with time, if you're going to issue a notice to correct, you have to give them a time within which to do it. I think the FIDIC provisions, certainly in 2017, say, you're going to ask anybody to do anything, you must give them a reasonable time in which to do it. So next slide. This is the guts of the termination provision for the employer. There are 5 grounds. There are some changes, as I say, from substance from 1999. I've tried to give you a bit of a heads up of what was going on in 1999 and how it's changed. Unsurprisingly, the first ground is a failure to comply with the notice to correct, which we've just seen. And the 2017 forms talk a great deal about failing to comply with an agreement or final and binding condition. I think that's under subclause 3, will be the engineering provision. So when you have an issue arises, it goes to the engineer as the first port of call under FIDIC, and you can either reach an agreement with the engineer or you can get a determination from the engineer. If you don't like the determination from the engineer, then you head off to your DAAB under clause 21. I think, a moment. Yes, sorry, I was just looking at my slides. I can see lots of pictures of you, but not slide. But clause 3 is the engineering provision. So if you fail to comply with an agreement or a final and binding determination of the engineer, and this is slightly different. A final and binding engineer is a determination that's been made by the engineer and not contested. So in effect, it's accepted, you have to comply with it. If you don't comply with it, then you could give rise to a right to terminate. And then the next provision, the DAAB decision, a binding or final and binding decision of a DAAB, which is different from the engineering provision, as you can see. But in respect of all of these breaches, the failure has to constitute a material breach of the contractor's obligation under the contract. And that's a provision which has caused and will continue to cause forever, I suspect, lots of scope for argument about whether or not it's a material breach of the contract. It does not itself, I think, have to be a repudiatory breach, but it does need to be a serious breach. And there's some law on that. Let's go to the next slide. So there are formal requirements about notices, and there's just a slide here to tell you that there are these formal requirements. And then also to make the distinction, there are some breaches which require you to give a notice of intention to terminate, and these are set out in grounds A to E, or there are other breaches, notably insolvency and corruption, where you don't have to give a notice of intention to terminate. You can move straight to a termination. And I've set these out on the slide. Let's go to the next slide. So an employer's notice, and this will be an intention to terminate, unless the contractor remedies it within 14 days, then the employer can terminate. If that right arises, the employer serves another notice. So you can see here all the way through these clauses, there is great emphasis on form. And if you get the notices wrong or you fail to serve the right notice at the right time, you cause yourself a lot of problems. And in respect of notices, under subclause 15.2 F and H, that's insolvency and corruption, one notice and it's effective immediately. So if you're going to terminate on grounds of insolvency, you've got to make sure that it comes within any definition of insolvency, rather than just perhaps trading insolvency or not being able to pay your bills. You really do need, and certainly administration wouldn't count, you really do need a liquidation or whatever the local laws describe of an equivalent state for the company. The termination is effective immediately. And when we say immediately, it's immediately upon receipt of the notice of termination. And as Bill was talking about that earlier, he mentioned that when you're serving the notice, you've got to be very clear with it. If you're going to serve it electronically, it's deemed to be served, I think, the day after it's been sent. But you've got to make sure it's been sent. So if you get some kind of bounce back from the computer, then it's not been sent and it's not been received. If you're going to serve it a paper notice, then better to serve it by registered post so that it's signed for and you've got a date of receipt. There are a number of ways in which you can serve notices under FIDIC. I think that's clause 1.3. Some of the ways will be chosen and set out in the contract data. Make sure that you do it exactly as has been agreed or as is prescribed in the contract. Now, we'll say here, the 2017 forms have more detailed provisions for action after termination. And you can slip up here just as well as you can slip up when you're giving your notice of termination or when you're going through the formal steps leading up to a termination. So you do need to be really careful. Let's go to the next slide. And really, valuation after termination, I've had tons of disputes about valuations after termination, and there are some cases on this. And although we're, Bill and I, we come from different places, we don't think that we're reinventing the wheel. And I can say that Corbett's have a great database of cases that have been decided under the FIDIC forms. And so if you're looking for a bit of law about FIDIC, because obviously there isn't much, because all of these contracts are subject to arbitration agreements. So if you're looking to see if there's been any legal decisions on a particular issue in FIDIC, that database is a jolly good starting point. And of course, the other good place to look is the Privy Council judgments on the website, because a lot of these decisions, in fact, come from former Commonwealth countries, and therefore they'll make it to the Privy Council. You may not actually see them. You see very few, in fact. FIDIC disputes in the High Court and Court of Appeal, certainly in the UK. And I guess that's provision, that's pretty much the same elsewhere. Payment after termination, there's a provision there in subclause 15.4, and it emphasises the employer's right to withhold payment until all the claims for completion and loss and damage, including delay damages, have been sorted out. I was looking at the JCT contract yesterday, and in fact, it says a similar thing, except unless any money is due under an interim certificate and you haven't issued a proper notice. So you do have to actually read these other provisions as to the consequences of termination, how you value anything that's due to the contractor, and when it's going to be payable, and what steps need to be taken to get to that position. So Bill, moving on. Termination for employer's convenience. I do actually give you a recap of the 1999 forms there. It's for convenience, it can be done at any time. What happens if there is such a termination? The employer must return the performance security forthwith and is not allowed to terminate, carry out the works himself or by a third party. And there, I give you the references to where the works are valued, which tells you also how the works are valued and paid to the contractor under the 1999 form. In the 2017 forms, same again, but the employer may not use contracts, documents, etc., until they've been paid sums due on termination, which is fair enough. If the contractor is in default, then the employer can take the documents. Where there's a termination for convenience, the employer doesn't get to grab the documents or equipment or temporary works until everything has been paid off. But note, as I said earlier, there's no prohibition against termination, so that you can do the work yourself or get someone else to do it if you think it's more convenient to do so. And I also mentioned clause 13, which is the variations clause, which is generally the position. If you're not in a termination situation, you can't omit and give work to others. And I think that's the same with most standard forms. Next slide, Bill. So the new clause is clause 15.6, and there I just explain what has to happen if there is a termination for convenience, and the contractor has to submit particulars of the work that's done, and additions and deductions and balances, and reach a final payment certificate. The claim in this termination for convenience, obviously, I think, includes loss of profit and other losses and damages arising from termination. So it's not a fault termination, so there's no reason that the contractor should leave a contract in these circumstances without being properly compensated. The engineer has to determine the sums due, and then you roll through the dispute resolution procedure if there's an argument about it. Under the 2017 form, there is inserted a date when the employer must pay off the contractor, because the other great situation with these things is a delay. The employer terminates for convenience and then strings out the process under which the contractor is compensated. So the 2017 form tries to manage that process. Next slide, talking about contractors termination. Again, there's a two-stage process. There's the notice of intention to terminate, and I give a recap of the 1999 form. I don't think there's anything particular I want to tell you about that. It's all very self-explanatory, so there's no point me just reading it to you. So let's go to the next slide. Again, here you have your notice of intention to terminate, but in 2017, they've added in, as I've said, they're trying to improve the adherence to the engineer as the first line of dispute resolution. So they want you to adhere to the engineer's determinations, or binding or final and binding DAAB decisions. So if there's a failure to comply with those obligations, you can give rise to a right to terminate, but it still has to constitute a material breach of the employer's obligation under the contract. So simple non-adherence per se may not constitute a material breach of the employer's obligation. Seems odd, but that's what the contract says. So these are the other grounds here that you have to issue a notice of intention to terminate for. Let me go to the next slide. 2017, so at the same process, there are some circumstances where you can terminate immediately, no notice of intention required. And new in 2017, which I thought was quite entertaining, but then you may not share that view, but I thought it was quite entertaining that actually the employer could be considered to be guilty of corruption or fraud in the 2017 form. In the 1999 form, it was just the contractor. But in the 2017 form, there is added a clause that the contractor may terminate immediately for corruption on the part of the employer. And in all cases, if you're terminating, it's without prejudice to your other rights or remedies, which is absolutely vital, because if you do get the form wrong, you may still be all right under a common law termination. And certainly we all as lawyers always argue both, because you can never be sure. So here under the next slide then, the consequences of the notices. The employer must remedy the default within 14 days. So it just mirrors the employer's termination provision. And then in respect of insolvency, in respect of corruption, again, mirroring the employer's rights, the termination is effective immediately. And delays and costs, including profit, and there are some cases on that, incurred during the 14-day notice period, are recoverable, subject, of course, and this is the same with all rights and obligations under FIDIC. Usually, if you're exercising them, you must comply with the notice provisions. So while you're learning about your rights to terminate or suspend or whatever you want to do, make sure you learn about your rights and obligations to give notices and what those notices must contain. Next slide, nearly there. So the contractor's obligations after termination, and these did alter a bit, although I said they altered a bit, mostly they altered where you actually could find where the obligations were in the contract. Some provisions were moved around the contract, and I think the new provisions are probably sensible, but if you're used to the 1999 forms, it was a bit annoying when you first read it. So obligations after termination, and these are the circumstances. So you cease or further work, well that I think is a given. If you're a contractor and you're terminating, you plainly don't want to continue with the work, except as instructed for protection or safety, of course. You can't just walk off the site and leave it. You deliver up the contractor's documents, plant and materials which have been paid for, and you remove your other goods, except anything that's necessary for safety, and then you go. Next slide. Regarding payment after termination, the employer is obliged to return under the 1999 form, and this is under 16.4, and this is where there is a movement of the performance security obligation. In 1999, 16.4 said, return the performance security, pay the contractor in accordance with the provisions of 19.6, and pay the amount of any loss of profit or other loss and damage. And in 2017, it says pay in accordance with subclause 18.6, so different subclause, pay loss of profit and damages according to subclause, subject to subclause 20.2 compliance, and then return the performance security, but you'll now find that obligation in clause 4.3.2 and not in 16.4. And I think
that's your last slide.
That was my last slide.
Well,
so that's how it goes then, people. That's how you terminate under FIDIC. But as I've said, if there is any other possibility for you, I would advise you not to do it.
And I would agree. Well, it depends. You know, quite busy at the moment, but if any of you fancy terminating in sort of, you know, a month's time or so, that'll be good. And if any of you really fancy, you know, a nice Christmas, New Year present for me, if you could just walk off site or just terminate or just do something absolutely ridiculous and then call me, that would be fantastic. A few points. Contract amendments, I haven't talked about them. Karen and I have talked about the contracts as they exist. And I fully accept that a number of you are contractors or in that position where you feel you can't amend them. If you can't amend the contracts, at least review them. Please review them. At least know what the clauses say and what the implications are for you. Just because it's being imposed doesn't mean to say that you can start on a job and not think about the things you will have to do or the notices that the employer must give you. You should at least know what is that for. Equally, amend the contracts. You know, I don't actually agree that contracts should be balanced because I think that employer owners of projects have a right to impose a certain number of conditions. For example, I insert in most of the contracts I amend a right for termination at convenience, and I negotiate that with the contractor saying, well, that will be on notice. I'm happy to put in that we won't use it in certain situations, but there's frequently reasons the client wants to do that. Now, as long as the contractor is aware and a compensatory mechanism is included, in my view, there's no reason why that shouldn't exist. What I don't agree with, what I don't encourage my clients to do is to use a contract to beat up a contractor or to gain an unfair advantage. So another area, corruption. As Karen says, FIDIC has changed. Who would have thought that employers' owners could be corrupt? Well, there's a new one. But this has important implications for supply chain. If you are an employer owner of a project, I think there are greater obligations on you now to consider the financial position of the contractor that you're employing, not just because of their ability to carry out the work, but are you going to have issues with corruption? What about their supply chain? And this does impact on different countries. And equally, as a contractor, you should look at the financial sourcing of your employer project promoter. And again, these have implications across. I think it's really important that you can think about all these things. We're going to come back to an open session, but just before we do, can I just say that in 26th of November, we have Donald, Charrett and Malith who are going to speak, and we're going to have a specific webinar on FIDIC because there's an awful lot. So those of you who don't know, Donald practiced in construction as a barrister. He's an arbitrator, mediator, he's a member of dispute boards, member of FIDIC's list of adjudicators, and he also practiced as an engineer, although I think even Donald might admit that's a little long ago. And Malith is also a chartered civil engineer, based currently in Sri Lanka, works on huge projects, sent me a list, and they're just enormous projects. They are people who are going to speak about FIDIC. The date at the bottom is actually wrong. It's Thursday. Our webinars are always on a Thursday. That should be the 17th of December.